Commissioner's Rules, Part 1, General Information and Advertising. So in this unit, we're going to cover the Commissioner's Rules that are part of the Arizona Administrative Code. They are not law, but they have the force and effect of law on real estate licensees. So basically, the Commissioner's Rules is basically like law for realtors. For the public, they're just rules, right? So this unit discusses some general rules, education, and advertising. In addition, compensation and documents will be addressed. So the topics, we're going to cover license renewal and changes in license status, branch offices and managers, continuing education requirements, advertising and case law, promotional activities, compensation, sharing disclosures, rules for conveying documents. So after we complete this unit, you're going to be able to state requirements for renewing a license, list the issues that require notification to the commissioner, discuss who may act as a branch manager and their duties, recite the requirements for advertising a property, discuss the case Barnes versus Lopez, state when and how premiums may be given to clients, list which parties who receive compensation must be disclosed, discuss the procedures for conveying offers. So let's go over our general license requirements, R4, Rule 4, Commissioner Rules. So it requires disciplinary action disclosure, questionnaire, fingerprints, and social security number of applicants. So a broker license may be issued only after a salesperson license is canceled. Requires filling of business and residence addresses. Residence addresses are not published. So Rule 4, 28-301, General Requirements. Licensee disclosure questionnaire, fingerprints, social security number, and proof of legal presence. So there's only one license, a broker or salesperson. So if you have a broker's license, you have a broker's license. If you have a salesperson license, you have a salesperson license. So it's only one license. You can't have two licenses. General requirements, legal name on license, file business and home address. License renewal and changes. So Commissioner's Rule R4. When a licensee renews early, the existing license remains in effect until expiration. If renewing a license late, the licensee must specify whether activities requiring a license were conducted after license expiration. If license renewal is untimely, which is called late, right? So then it's expired, right? Like milk goes bad, it's expired. So if you renew late, it's expired. The licensee must pay a penalty fee. If the licensee conducted real estate activity while expired, the real estate department may take administrative action. Requires licensees to notify commissioner within 10 days of misdemeanor, right? So if you catch a misdemeanor or a felony conviction, you have to notify commissioner within 10 days. Adverse judgments in real estate civil suits. Restriction, suspension, or revocation of a professional license. Change of business or personal address. Requires licensees to notify commissioner within 10 days of misdemeanor or felony convictions, adverse judgments in real estate civil suits, restriction, suspension, or revocation of a professional license, change of business or personal address. So Rule 4, license renewal and changes, early renewal, existing license still effective. Late renewal, you need to disclose activity, late penalty, or if you have administrative action. So you must notify ADRE within 10 days. If you have a felony or a misdemeanor or a misdemeanor conviction, right? So if you're convicted of a misdemeanor, restriction, suspension, or revocation of professional license. So if a licensee is not renewed in a timely manner, a late fee will be charged when the license is renewed. This is true. To obtain a real estate license, an applicant must complete a questionnaire to disclose any felonies, misdemeanors, or license revocations. This is true. So to obtain a real estate license, an applicant must complete a questionnaire to disclose any felonies, misdemeanors, or license revocations. A real estate salesperson may work for 2 different real estate brokers at the same time. This is false, right? You can only work for 1 broker at a time. The ADRE must be notified of a change of the licensee's home address within 10 days of the change. This is true. So if you have a change of address, who do you need to notify within 10 days? ADRE. If a licensee fails to renew the license is what? Is suspended? This is false. Right? It's not going to be suspended. It's expired, like bad milk expires when it's too old. Right? So if you are renewing your license and you fail to renew on time and it's late, it becomes expired, right? You don't get suspended. Suspended would mean some disciplinary action that was taken against your license, or if it was revoked or terminated. Those are different than expired. Expired meaning it just, you didn't renew on time. The other 3 are disciplinary action was taken against your license. If a licensee conducts real estate business after the license expiration, the licensee will not be penalized. False, right? So you will be penalized. You cannot conduct any type of real estate without an active real estate license. It cannot be inactive. It cannot be expired. You cannot conduct any real estate transactions when it's expired or inactive. It has to be active. A salesperson may sever themselves from a brokerage firm without the broker's permission. True. So you don't need your broker's permission to sever. If you don't want to be with the company, just go to adre.gov, sever, and then get hired on with the new brokerage. As you don't even need to talk to them as an independent contractor. You have that right. Article 3, branch officer, branch office manager. Part 4, the commissioner's rules. A salesperson or associate broker may act as a branch manager. The commissioner must be notified of a change of branch manager within 10 days. If a branch manager is an associate broker, the employing broker may authorize the branch manager to perform designated broker functions. He or she may review initial contracts, supervise activities of a salesperson and brokers, hire and sever licensees, sign compensation checks, be a signer on trust accounts, write checks from the broker's trust account, be responsible for all trust account funds administered by the branch. No branch office license is required for an on-site subdivision office. So again, no branch office license is required for an on-site subdivision office. Article 4. So salesperson and associate brokers must attend at least 24 hours of continuing education every 2 years. Designated brokers, self-employed brokers, and associate brokers with delegated authority to review and initial contracts and to hire several licensees, must attend 30 hours, including 3 broker management clinics every 2 years. Education is required in specific course categories. So if you're a DB and you know how, and you have responsibility to review and initial contracts, you need to do 30 hours of continuing education, and that's 9 hours of broker management clinics. There's 3 of them, and they're 3 hours apiece. So for branch office or branch office manager, salesperson or associate broker may act as a branch manager. The commissioner must be notified of a change of branch manager within 10 days. If a branch manager is an associate broker, the employing broker may authorize the branch manager to perform designated broker functions. He or she may 1. Review initial contracts, supervise activities of salesperson and brokers, hire and sever licensees, sign compensation checks, be a signer on trust accounts, write checks from the broker's trust account, be responsible for all trust account funds administered by the branch. So for the branch office, on the manager, salesperson or associate broker, right? Who could be the manager? A salesperson or an associate broker. Now, designated broker acts can be an associate broker only. Branch office license required except on-site subdivision. Salesperson and associate brokers, 24 hours. Designated brokers, they need 30 hours of continuing education. A manager of a branch office must be a licensed broker. False. Right? A manager of a branch office does not have to be a licensed broker. For an on-site new home subdivision office, a separate branch office license is required. False. Right? For an on-site new home subdivision, a separate branch office license is not required. The continuing education requirement for salesperson and associate brokers is 30 hours every 2 years. False. Right? Salespersons, they 24 hours, and brokers is 30 hours. Salesperson and associate brokers is actually 24 hours. If it's a designated broker, then it's 30 hours just because they have to review initial contracts. The continuing education requirement for designated brokers and associate brokers with delegated authority is 30 hours every 2 years. True. Designated brokers and associate brokers with delegated authority must complete 9 hours of broker management clinic classes every 2 years. True. Advertising by a licensee. So no blind ads. So what that means is a licensee is acting as an agent, shall not advertise property in a manner which implies that no licensee is involved in the transaction. So you can't have what's called a blind ad, which where a realtor who's actually advertising and it doesn't seem like there's a realtor involved, right? That's a blind ad. Owner agent requirement. That's any licensee advertising the licensee's own property for sale, lease, or exchange shall disclose their status as owner agent. So this is the owner agent requirement. So I am a realtor. So if I am going to sell my own house, what do I need? I need to say owner-agent. So you folks who are taking our class, you're going to become realtors or brokers. If you want to sell your own house, you have to disclose that you are a owner-agent. That is the owner-agent requirement under Article 5 of the Commissioner's Rules, under Rule 4, under advertising. What are advertising requirements for websites? So each single page should identify the real estate company at or near the top of the web page. What are advertising requirements for social media ads like Facebook? So the brokerage company should be identified in the ad or post. Is an ad that contains only a phone number or an email address in compliance with this rule? No. What do you need? You need the company's name to be prominently displayed. Owner agent requirement, you have to disclose your license status. So you put house for sale and you need to put owner agent. Does this rule apply to ads for agent owned properties for rent or lease or exchange? Yes. So say if you don't own the house but you're leasing the house, or if you're gonna rent it or lease it or exchange it, you still have to put owner agent because you have specialized knowledge that the public doesn't have. So you need to let the public know that you're an agent and they're dealing with an agent that has specialized professional knowledge in real estate. Are there ads it doesn't apply to? No. So all advertising, you have to put owner agent. If you're an owner, if you're an agent and you're selling your own property. Does it apply if the listing agent is a member of the LLC that owns the property? Yes. So again, does it apply if the listing agent is a member of the LLC that owns the property? Yeah, still applies even if you're a business and you own the business and you're advertising it. Does it apply to inactive status licensees? Yes. So if you're an agent and your status is inactive, but you're doing some advertising, you still have to disclose owner agent. All real estate advertising by licensee must include the name of the brokerage firm. True. Right? All real estate advertising by licensee must include the name of the brokerage. Ads on social media platforms are not required to include the brokerage company's name. False. Ads on social media are required to include the brokerage company's name. A real estate company's website must have the legal name of the brokerage company on every web page. True. A real estate company's website must have the designated broker's name on every web page. False. So again, a real estate company's website does not have to have the DB's name on every web page, but you have to have the company's name on every web page. A salesperson may advertise a property with an ad that contains the salesperson's email address, but not the company name. False. You need to have the company name. When erecting a sign advertising the sale of property owned by a licensee, the sign must contain the wording owner agent. True. This is true. The owner agent advertising requirement does not apply to ads for agent owned properties that are for rent. False, right? Even if the property's for rent, you still, if you're an agent and you're advertising as an agent and you're going to be renting the property and you own the property, you still need to put owner agent, even if it's for rent or exchange or lease. If an LLC owns a rental house that is listed for sale by one of the LLC members, any ads must include the term owner agent. Answer is true. Owner agent advertising requirement does not apply to inactive licensees. False. If your license is inactive, but you're doing advertising and you're an agent, you still have to put owner agent. So, accurate claims. All advertising must contain accurate claims and representations and fully state factual material. Licensees shall not misrepresent facts or create misleading impressions. So, this is Commissioner's Rule, Article 5 under advertising. So, let's talk case law. Barnes versus Lopez. This is a topic on misrepresentation. So here's the brief summary. 1972, Barnes, he's the seller. He listed a property with Solane Realty through salesperson Cajero. The listing stated the zoning as business, B2A. The zoning was partially B2A and partially R2, residential. So for those folks who don't know zoning, B2A is business, R2 is residential. A sign on the property advertised it as B2A. The listing salesperson, Cajero, told the buyer, who was Lopez, that Lopez could build any kind of business you want on the property. The seller, Barnes, told Lopez this is the only piece of property, zone B2A, that is left in that area. After closing, Lopez discovered the actual zoning. That's partially residential, right? R2. Lopez claimed that he was damaged by misrepresentation of the seller and real estate company. So, what's the decision? The trial court rendered judgment against Barnes and Solberg Realty in favor of Lopez. So the appeals court affirmed that judgment. So here's the application. The representation of the agent and seller in statements and advertising as to the B2A zoning was a misrepresentation of an existing fact because it was actually partially R2 residential and you can't build any business that you want, right? Because it has that partial residential R2 zoning. So commissioner's rules require written disclosure of material facts that adversely affect the consideration to be paid. So Lopez won because the advertisement only stated the B2A and it didn't have the partial R2. So broker's name needs to be clear and prominent. Rule 4, all advertising must include the name of the employing broker in a clear and prominent manner. The employing broker's name should appear on the top of every web page. You need to have accurate claims, meaning there's no misrepresentation, no false or misleading claims, like how we saw in Barnes versus Lopez, where Barnes was advertising business property, but it was actually business and residential, so you can't build any business you want. So you can look at this offline. What are some examples of licensees making inaccurate claims? So we saw Barnes case law, Barnes versus Lopez, zoning misstated on the sign, and that is deemed a misrepresentation, right? So we will learn from this case law that if it's partially residential R2, you need to include that as well. Broker name must be clear and prominent, includes internet advertising, top of every web page. So what constitutes clear and prominent? Clear is going to be, the definition of clear is going to be bright, easily seen, easily heard, plain, and prominent is going to be basically viewable. So does this rule apply if a specific property is not advertised? No. Rule 4 of the Commissioner's Rules provides an exemption. However, it is always good practice to include the brokerage company's name in any ad. If a licensee does not use company branding, might it violate franchise rules or other agreements? Yes, this may not be an ADRE issue, but brokers should review their agreements with third parties. If a real estate ad incorrectly states the zoning of a property, the licensee has no liability for the inaccurate information. False, right? So the licensee has liability for the inaccurate information. So if a real estate ad incorrectly states the zoning of a property, the licensee has liability for the inaccurate information. In any ad, including signs, the real estate company's name must be included in a clear and prominent manner. This is true. On a real estate salesperson website, only the home page must the name of the real estate company be located. This is false. So on a real estate salesperson website, only the home page. So it's not just the home page. Altering the property's photo in a listing or an ad could lead to a misrepresentation. True. So altering a property's photo in a listing or an ad could lead to misrepresentation, right? So never use like Photoshop when you're taking pictures of properties. Just take the raw pictures and then post those. In the Barnes versus Lopez case, the licensee was found to have misrepresented the property because of a misstatement in advertising that the buyer relied on. This is true. For the broker's name to be considered to be clear and prominent, a consumer should be able to easily determine which brokerage company has placed the ad. True. So again, for the broker's name to be considered to be clear and prominent, a consumer should be able to easily determine which brokerage company has placed the ad. So advertising, according to Commissioner's Rule 4, advertising other companies' listing. When advertising other companies' listing, the ad must display the name of the listing broker in a clear and prominent manner. The designated broker shall supervise all advertising. Advertising an acre, right? A licensee shall not use the term acre unless referring to an area of land, and it must represent 43,560 square feet. So it's kind of a famous number. You got to remember 43,560, 43,560, 43,560, 43,560 square feet is what? Is an acre. Written consent to place sign. A salesperson or broker shall secure the written consent of the property owner before placing a sign on the property. Trade names. Trade names must be used as licensed by ADRE, not only an abbreviation or logo thereof. Electronic advertising. Any internet or other electronic technology that targets Arizona residents is included in and regulated by the Commissioner's rules. Advertising and other companies' listings. So you must include the listing company's name. So if you want to advertise, someone else's listing, you must include the listing company's name. Ad supervision. The broker must supervise ads, right, for ad supervision. So what are the exceptions to this rule? So Rule 4, R4-28-502J, provides an exemption when a specific property is not advertised. However, brokers may want to have policies regarding advertisements or solicitations of a general nature. So how many square feet is in an acre? 43,560, 43,560 square feet. So so it's like almost a football field, right? If you think about Cardinals football field, it's about an acre. That's 43,560 square feet. No commercial acres, no subdivision acres. Written consent for signs. You need to have written consent to put up a sign. When the ad is expired, you need to remove it. At the request of the owner, you need to remove the sign as well. Trade names per ADRE licensing. Logo, if you just have a logo for the trade name, that's not going to be sufficient. Having electronic ads, regulated if targeting Arizona residents. So the designated broker is responsible for supervising all advertising. True, right? So your DB, they're really the ones that's going to be responsible for supervising all advertising. In order to place a sign on a property, the owner's written permission is required. True, right? So in order to place a sign on a property, the owner's written permission is required. One brokerage company may create ads that use properties listed by other companies without using the names of the other companies in the ad. False, right? Again, one brokerage company may create ads that use properties listed by other companies without using the names. No, you have to use the names of the other companies in the ads. So if you want to advertise someone else's ads, you can, but you must include the other company's name in the ad. When using the term acre in an ad or any other representation, an acre refers to 43,560 square feet. Right? So the answer is true. A real estate company may use a well-recognized company logo in ads without using the actual company name. False. Right? A real estate company may use well-recognized company logo in ads without using the actual company name. No, they need to use the actual company name. Promotional activities, Rule 4, under Article 5 of the Commissioner's Rules, licensees shall not describe a premium offered at no cost or reduced cost as an award or prize, or use a similar term. The terms, cost, conditions, restrictions, and expiration date of an offer of a premium shall be clearly disclosed in writing before the offeree participates in the offer. A licensee may not solicit, sell, or offer to sell an interest in a development by conducting a lottery, contest, drawing, or game of chance to influence a purchaser or a prospective purchaser. A subdivider, timeshare developer, or membership campground operator may apply for approval to conduct a lottery, contest, drawing, or game of chance. So promotional activities, premiums are okay, but you can't use specific language like prize or award. May a licensee offer to give a client a new TV, pay moving expenses, or send the client on a cruise for doing business with that licensee? Yes, because the person is a client. Premiums are no different than commission reductions or rebates. So say you want to offer $1,000, right, to your client. They have to be your client, and giving them a premium, right? You're not saying a bonus or a prize, but you're saying I'm gonna give you a premium, right? So instead of reducing my commission, I'm gonna give you a TV, brand new TV, $1,000 TV, or I'm gonna pay some moving expenses, or I'm gonna send you on a cruise. You're really using their own money, right? So instead of 3%, I'm gonna do 2%, and I'm gonna buy $1,000 TV. You're really reducing your commission, and you're giving that premium. May a licensee offer non-clients a premium or compensation for referring clients to the licensee? No. So this violates licensing statutes. So the big thing here is, say you do a good job with somebody, and that your clients, your past clients, they refer you some business, and they want to be compensated. They can't get compensated because they don't have a real estate license. That's pure, plain and simple. Receiving compensation for assisting or directing in the procuring of prospects for a real estate transaction requires a license. So, yeah. And they can also get in trouble if they receive compensation because okay, so a real estate licensee may use the following language in an ad. Buy a home from me and you will receive a free cruise to Alaska. Answer is true. An unlicensed former client may be paid compensation for referring business to a licensee. False, right? Unlicensed former client may be paid compensation. So the key word here is unlicensed. When offering premiums to clients, all the terms must be disclosed in writing. True. So when you're offering premiums to clients, all the terms must be disclosed in writing. A licensee may conduct a contest or lottery when soliciting offers to purchase. This is false, right? A license uh, may conduct a contest or lottery when soliciting offers to purchase. So a licensee may not conduct a contest or lottery. A subdivider or timeshare developer may use a lottery to attract business without ADRE approval. This is false, right? A subdivider or timeshare developer may use a lottery to attract business without ADR approval. They may not use the lottery. Compensation sharing disclosure. A real estate broker shall disclose to all parties in a transaction in writing before closing the name of each employing broker who represents a party to the transaction and who will receive compensation from the transaction. Compensation to salespersons or referral fees to other brokers are not required to be disclosed unless paid through escrow. So rule 4, compensation sharing. Compensation is disclose all brokers representing a party. So here you have settlement charges, and you have to disclose all brokers representing a party. So here you can see there's 10 grand to ABC Realty and 10 grand to XYZ Realty. 10 grand is going to the buyer's agent, 10 grand is going to the seller's agent. So you can easily write this up from the title company, a little cost sheet analysis where you can see how much money is going to go to each agent. When must referral fees be disclosed? So Rule 4-28-701 requires that compensation of brokers who represent a party to a transaction be disclosed in writing prior to closing. So here's a note. The compensation to a referring broker not representing a party in the transaction would not need to be disclosed. However, any referral fees must be disclosed if the referral fee is paid directly from escrow. So here the caveat is that if you're being paid from escrow, you have to disclose that referral fee. When must commissions to salespersons or associate brokers be disclosed? Only when the commission is paid by the escrow company. What are the requirements regarding instructions to escrow to disperse commissions directly to licensees? The designated broker must, in writing, authorize the escrow company to pay commissions on each specific transaction directly to the licensees on the broker's behalf. Only the designated broker may give written authorization to escrow on all splitting and or payments of commissions. Commission checks should be delivered by escrow directly to the employing broker along with the closing statement for designated broker verification and documentation. So when paying referral fees, what should the referring brokerage require from the receiving brokerage company? So the brokerage company should have a written referral agreement between the two companies, a copy of the brokerage's real estate license, and a completed IRS Form W-9. To comply with Arizona Commissioner's rules, only compensation paid to companies that represent a party to the transaction must be disclosed. Answer is true. So again, to comply with Arizona Commissioner's rules, only compensation paid to companies that represent a party to the transaction must be disclosed. Referral fees paid to out-of-state companies must be disclosed to clients. False, right? Referral fees paid to out-of-state companies must be disclosed to clients. Referral fees paid to out-of-state companies does not need to be disclosed to clients because they're not a party to the transaction. Commissions paid to salespersons must be disclosed to clients when the commission is paid through escrow. True. So again, commissions paid to salespersons must be disclosed to clients when the commission is paid through escrow. In order for an escrow company to pay compensation to a salesperson or associate broker, the designated broker must give escrow a written instruction in each transaction. True. When paying a referral fee to a salesperson in another company, the referring company should make certain the company is licensed and may pay the salesperson directly. False, right? So when paying a referral fee to a salesperson in another company, the referring company should make certain the company is licensed and may pay the salesperson directly. So again, you can't pay the salesperson directly, they're paid through the broker. So Article 8, documents, Commissioner's rules, are Rule 4, conveyance documents. So upon execution of any transaction document, a licensee must, as soon as practical, deliver a legible copy of the signed document and final agreement to each party signing the document. So here's offers. During the term of a listing agreement, a listing shall submit as soon as practical to the licensee's client all offers, written or verbal. Upon receiving permission from the client, the licensee, acting on behalf of the client, may disclose to all offerers the existence and terms of all additional offers on the listed property. The licensee shall submit to the client all offers made prior to closing. A licensee is not released from this duty by the client's acceptance of an offer unless the client instructs the licensee in writing to cease submitting offers. The licensee may voluntarily submit offers to the client regardless of any limitations contained in the listing agreement and may submit offers after the listing agreement is terminated. The broker shall retain true copies of the executed and delivered escrow closing statements. Conveyance documents, so copies to all parties as soon as practical. So what does as soon as practical mean? So this is situation dependent, but if possible, when consumers sign a document, they should receive a copy immediately. Rule 4-28-1101C requires that a licensee shall expeditiously perform all acts required by holding a license. So offers must submit all offers need to be submitted in writing, written or verbal. They need to be submitted promptly up through closing. The exception is when you have a written instruction from the seller. Licensee may submit even if instructed not to or after listing expires. Must verbal offers be presented? Yes. A salesperson or broker shall promptly submit any and all offers. So even if it's a verbal offer, that needs to be, you need to tell your seller about that type of offer. Does this rule apply to offers to lease? Yes. All offers to buy or lease must be submitted. May terms of other offers be disclosed to other offerers? Yes. However, such disclosure may not be in the client's best interest. The pros and cons of doing so should be discussed with the client. What are proper procedures for backup offers contracts? The backup offer should be contingent upon mutual cancellation of any prior contract. The party making the backup offer should acknowledge that they understand the seller is currently obligated by a prior contract to sell the property to another buyer. When is a licensee released from the duty to present all offers? When the client instructs the salesperson or broker in writing to cease submitting offers, or when otherwise provided in the listing agreement, lease, or purchase contract. What should be done to release parties if a transaction falls through? The parties to the transaction should sign a mutual cancellation document. So, closing statements, broker to retain true copies. So, commissioner's rules require that as soon as practical, a client be given a copy of any document the client signed. This is true. Once an offer has been accepted by the seller, it is not necessary to inform the seller about other offers. False. So once an offer has been accepted by the seller, it is not necessary to inform the seller about other offers. That is not true. So you still got to tell the seller about other offers. A licensee is prohibited from presenting offers once the listing has expired. False. Right? A licensee is not prohibited from presenting offers once the listing has expired. All offers except verbal offers to lease a property must be presented. This is false, right? All offers except verbal offers to lease a property must be presented. No, all offers, if it's verbal or written, has to be presented. The terms of an offer may never be disclosed to other persons making offers. False. The terms of an offer says may never be disclosed, always has to be disclosed to other persons making offers. Backup offers contracts should be contingent on mutual cancellation of the prior contract. This is true, right? So if you have a backup offer, it's contingent on mutual cancellation of the prior contract. A transaction is not terminated until all parties sign written cancellation instructions. This is true, right? Transaction is not terminated until all parties sign written cancellation instructions. So just because you want to terminate the contract, it's not done until both parties have signed that they want to cancel. So definitions of real estate language and concepts represent a critical element of the licensing exam. So an acre has 43,560 square feet. Lottery or contest is not allowed in advertising property for sale or lease. So you can't have a lottery or a contest. Designated broker, that's the person responsible for all advertising. Owner agent must appear in ads for licensees own property for sale. So let's go over the unit summary. To obtain and or renew a license, applicants must complete a disciplinary action disclosure form. Licensees must pay a penalty for late license renewal. Within 10 days, the commissioner must be notified of the following: misdemeanor or felony convictions, adverse judgments, disciplinary action relating to any professional license, change of business or personal address, salesperson or associate brokers may act as branch managers. Salesperson, associate brokers must complete at least 24 hours of continuing education to renew their license. Designated brokers must complete at least 30 hours of continuing education to renew their license. Licensees may not advertise in any manner, which might imply that no real estate agent is involved in the transaction. When advertising a property that a licensee owns, the ad must include the wording owner agent. All ads must contain accurate facts and not misrepresent the property. The case Barnes versus Lopez shows that misstating material facts in an ad is a misrepresentation. In any ad, the broker's name must be clear and prominent. When advertising another company's listed property, the name of the listing company must be displayed. The designated broker must supervise all advertising. When using the term acre, it means 43,560 square feet. The owner's written permission is required to place a sign on a property. Licensees may not use the term prize on or award when describing a premium. You can offer a premium, it's like reducing your commission. The terms of any offer of a premium must be fully and clearly stated. The brokerage firms that represent any party in a transaction must disclose compensation to all parties, and all offers must be presented to the client. All right, so next up, we'll go over to Unit 7. We'll talk about Arizona Commission's Rules, Part 2, Professional Conduct.